Hello and good evening. My name is Joshua Hacker. I'm the Executive Director of the Moot Court Board here at Albany Law School, and I welcome you to the final round of the Gabrielli Appellate Advocacy competition this evening. You're all in for such a treat. These competitors, these finalists have put in so much work to be in these chairs, and honestly, it's going to be such a great night to be here and witness exactly what they're going to argue and say before the Court of Appeals in the Northern District here tonight. So, what makes tonight possible? It can be broken down into 6 groups of people, starting with one, the administration of this school. So as the Moot Court program and this competition, on behalf of this competition as well, we are incredibly thankful for John Collins, Julie Pierce, Lauren Minot for all the work they do behind the scenes. They draft up our pamphlets, they help edit our computer work and stuff like that. They help schedule the rooms. And for this competition, with all the competitors that we've had and having it run since February, there have been a lot of rooms that have been needed to be scheduled. So we thank them for all their hard work that they do behind the scenes. Next, I'd also like to thank this competition's faculty, or not this Moot Court program's faculty advisor, Professor Johar. She also has done so much work. She's answered all of our questions and is personally responsible for so much of the success of this board and this program. So we extend our sincerest thank you to her. On a similar vein, we also thank Professor Wetmore, this competition's faculty advisor, for similarly the same work that he's put in and helping Liam draft the problem starting in the summer, continuing editing it throughout the fall, and getting this problem up to near perfection that we've received so many compliments on from judges throughout the last couple months. So thank you again, Professor Wetmore, for all that you do for this competition and the program itself. Next, I want to thank the competition chair, Liam Nugent, for all the work that he's put in. So like I mentioned, he's worked very closely with Professor Wetmore, started in the summer, continued through the fall, and his attention to detail has been spot on. He's also equally as valuable, or maybe that's not the right word for it, but equally contributory towards writing this problem and getting it to its success. And we're so proud to have had him on the board. I am so thankful to have worked with him. He's such a joy to work with when there's been questions, when issues have arose with competitors or scheduling. The communication has been so great with Liam. So again, thank you, Liam, for all that you do. And I hope you enjoy the successes of this night, watching your problem come alive. Next, the competition associate, Phil Getsin. Similarly, he has helped Liam as part of that team. He's helped schedule judges. He's helped organize the rooms, clean up the rooms, chaperone competitors to the rooms. So again, Phil, we thank you so much for all the work you've put in as part of the Moot Court board itself too. Next, I'd be remiss if I forgot to mention the Moot Court board, most of which are sitting here in the reserve seats, but you've seen them when you walked in, handing out pamphlets, and for any of the other competitions that you've attended this year. None of this would be possible without the Moot Court board, and I thank each and every member of them for all the hard work that they've done as well. And lastly, but not least, the competitors of this competition. So this competition starts out with writing a brief in January. It gets submitted in February, but writing that brief, believe me, is no easy task. That involves hours of legal research, reading through the problem, getting that to a submittable quality, going through the citations, Blue Book style, of course. So I commend all the competitors for all the hard work that they've done, starting with the brief and then going into the preliminary rounds and arguing as well. This is not an experience that you get in every class in law school. So I'm personally very thankful to have been a part of these competitors' lives and their ambitions by competing in Gabrielli itself. And I commend them to their legal careers going forward, as I hope this really leaves a lasting impact from the feedback that they've received from judges, from the communications they've had with the school faculty, and even just competing against their peers. And last, I'd like to give a special thank you to our volunteers and judges in the community, the local attorneys who come in and make all this possible. Their time and their expertise has been so invaluable and has made such a difference in so many competitors' lives, including myself. I can proudly say I would not be here standing before any of you if I did not compete in Gabrielli last year. And finally, I'd like to extend my sincerest congratulations to our finalists and the best of luck to them as they compete here tonight. It is now my pleasure to introduce our president and dean, Dean Carlarn. Thank you so much.
All right, good evening, everyone. It's definitely nicer inside right now than outside, so we all made a good choice. It's a pleasure to be here with you tonight for the culmination of the Domenick Gabrielli Appellate Advocacy competition, one of our most fantastic events at the law school. Now, this event, named in honor of Domenick Gabrielli, a distinguished member of the Albany Law School's class of 1936 and a former associate judge of the New York Court of Appeals, reflects a legacy of excellence in appellate advocacy that continues to really define this institution. Now, as you can read a little bit more about in your program, which hopefully you all have, after graduating from Albany Law School, Judge Gabrielli delayed the start of his legal career to serve in the Navy during World War II. He then went into Steuben County District Attorney's Office and ultimately had a distinguished tenure on the Court of Appeals. His career is truly a powerful reminder of the many paths a legal education can take and of the impact that those in those paths can have. Now, I have no doubt, and I know many of the folks in this room, so I have no doubt that among us tonight are future leaders who will build equally meaningful legacies. Now, as many of you know from experience, as competitors or judges, Albany Law School's phenomenal Anthony V. Cardona 70 Moot Court program plays a truly central role in helping Albany Law prepare our students to practice, to serve, and to lead. Now, within this already stellar program, the Gabrielli Appellate Advocacy Competition creates the opportunity for our second-year students to truly immerse themselves in the intricacies of appellate practice and really begin that kind of iterative process of honing their written and oral advocacy skills, something that's incredibly important to your practice, future practice. For weeks now, as you just heard, the competitors in this competition have delved into complex legal issues, crafting persuasive appellate briefs, and delivering compelling oral arguments before panels of esteemed judges, sometimes very hot panels. Maybe tonight a hot panel, we'll see. And this competition holds a special place in the history of Albany Law School as our longest running moot court competition. The students who are finalists tonight have competed over the past several weeks with numerous other teams through quarterfinal and semifinal rounds to arrive here tonight and to have the incredible and no doubt wonderfully intimidating and definitely not to be forgotten opportunity to argue in front of tonight's judges, 2 judges from our Court of Appeals and of course a judge from the Northern District of New York. Truly a career-defining moment and something that I'm quite sure they will count as a highlight in their legal careers. Now, I want to extend my very sincere congratulations to all of the competitors and to our finalists, Ethan Beach, Luke DeFio, Silas Smith, and Connor Skehan. Congratulations on reaching the final round. I just want to pause and actually just say congratulations. You made it here. That's very, very impressive. Your performances have been outstanding, and you've really, truly earned your place here tonight. So you're about to showcase the very best of Albany Law School's appellate advocacy talent, and I'm honestly so proud, and I can't wait to watch. So now let me pause to extend my very sincere thanks to the distinguished panel of judges who are here with us tonight. Our very own Judge Garcia, Albany Law School class of 1989, Judge Cannataro, and of course, Judge D'Agostino. And a huge thank you on behalf of the entire Albany Law School community. So thank them for being with us tonight and being willing to share their time, their expertise, and their valuable insights, and to really help shape our students into not just good, but great future appellate advocates. This is truly an honor for our school, and it's an incredible opportunity for these 4 wonderful finalists. I'm sure they aren't nervous about it at all. I also want to express, they're more just like, can you finish so we can start, please? Yes, I will finish so we can start. I also want to express my sincere thanks, though, to all of the students, the faculty, the staff, and the alumni who've dedicated their time and expertise to judging, to coaching, and to organizing this competition. A huge amount of work goes into it, as you heard. In particular, I do want to add my thanks to Professor Johar and Professor Wetmore for their incredible leadership and really just dedication to the students, which students see and feel in every kind of way. Your commitment to mentoring our students and providing them with the kind of invaluable experiential learning opportunities is deeply appreciated, essential to the success of this program, but also shapes who we are as a law school. And finally, last but definitely not least, I want to recognize and really celebrate the Moot Court Executive Director, Joshua Hacker, who you heard from. I lost him now, but Joshua, you know where you are. The Moot Court Board, and a special thanks and huge congratulations to Liam, who all of the work culminates tonight. So well done and congratulations to you, our competition chair. And then Phillip Getsin, who's still hiding back there, but you'll see him a little bit later, our competition associate. Now, I do actually have to constantly remind myself on these nights that this is a student competition because it doesn't feel like it. It's run like a professional endeavor. The professionalism, the organization, and the care that every single person who's involved brings to this competition are remarkable. And it really sets a standard and reflects extraordinarily well on Albany Law School. So we're very proud of your work and very grateful for your work. And now I have the pleasure of introducing our competition chair, Liam Nugent.
Thank you, Dean Carlarn, and thank you all for being here. It has been my absolute honor to serve as the chair for this competition. I am so excited to welcome you all to our final round. As the Dean mentioned, the Moot Court program and this competition in particular are decades-old Albany Law School traditions. And throughout the course of this semester, the Albany Law School community has shown just how these institutions are able to thrive year in and year out. In your program, you will find that 16 different active and retired judges, 25 different local attorneys, 8 faculty members, and 71 current Albany Law School students came together to participate in this competition. Since our first preliminary round back in early February, each of those individuals gave up hours of their time, sometimes multiple times a week and often multiple rounds per night. But no matter what, every individual who I had the pleasure of greeting at our East Foyer entrance arrived with a smile on their face and a genuine excitement to be a part of this tradition. So it is thanks to this dedication that our competitors were given the opportunity to experience for the first time the rigor and pressure of an appellate courtroom within Albany Law School's learning environment. This competition is a formative experience for those of us who have yet to enter the legal field, and we students are so fortunate to have an Albany Law School community that really values this competition. So thank you to everyone who participated. To every student who competed this year, and I know many of you are in the audience, criminal case. It has been appealed to the state of New Scotland's highest court, the Court of Appeals. The appellant defendant, Donovan Miller, was originally indicted for robbery, criminal possession of a weapon, and larceny. There are now 2 Fourth Amendment issues on appeal. The first regards whether the arresting officer had probable cause to arrest Donovan Miller, and the alternative second issue is whether the evidence found on Donovan Miller's person pursuant to that arrest could be admissible via the inevitable discovery exception to the Fourth Amendment. The competition will proceed as follows this evening. Each competitor will have at most 15 minutes to argue before our esteemed court. The appellant team will have up to 3 minutes to reserve on a rebuttal. After both teams have argued, our judges will retire to their chambers and deliberate, and then return to announce our 2026 winner. As was mentioned earlier, our finalists tonight are Ethan Beach and Luke DeFio, representing the appellant, versus Connor Skehan and Silas Smith, representing the respondent. Again, as was mentioned, we have the privilege of a truly spectacular bench. The Honorable Judge D'Agostino, the Honorable Judge Michael Garcia, and the Honorable Judge Anthony Cannataro. Now, I will turn the courtroom over to our bailiff, Jack Reppin, to begin the oral argument. Thank you all for being here, and good luck.
All rise. Hear ye, hear ye, hear ye. The Court of Appeals of the State of New Scotland is now in session. All persons having business before the court draw near and be heard. Sitting on this bench are Judge Mae D'Agostino, Judge Michael Garcia, and Judge Anthony Cannataro. Please be seated. The case for oral argument is the people of New Scotland versus Donovan Miller.
Thank you, counsel.
Good evening, Your Honors, and may it please the court. My name is Luke DeFio. Along with my co-counsel, Ethan Beach, we represent the appellant Donovan Miller. I'll be addressing the probable cause issue, and I would like to reserve 3 minutes of my time for rebuttal.
You have it.
Thank you. We respectfully request this court to reverse the appellate court's decision, which erred in ruling that Officer Baker had probable cause to arrest our client.
Well, he saw your client in the vicinity of the crime, correct?
Yes, Your Honor.
Walking a tad briskly, correct?
Yes, Your Honor.
Hands in his pocket.
Yes, Your Honor.
Doesn't an officer have a right to make certain assumptions under those circumstances?
Your Honor, certain assumptions are subjective beliefs. To have probable cause, you need to have objective facts that link the defendant or the suspect to the crime. It was, Your Honor. It was 2 minutes after the crime.
The defendant actually moving in a direction away from the scene of the crime when he was stopped?
He was, Your Honor, but so were countless other innocent people. Mr. Miller's conduct doesn't even amount to reasonable suspicion. We merely have a man walking quickly, wearing a hoodie in semi-warm weather within 2 minutes of the crime.
But flight goes to the concept of mens rea, doesn't it?
Correct, Your Honor. Cibron v. New York explains that flight does go to the concept of mens rea, but the Cibron test not only requires flight, it also requires specific knowledge linking the suspect to the crime. Here, we don't even have flight. Officer Baker admitted that on page 38 and 39 of the record that he doesn't know whether Mr. Miller actually saw his police vehicle or if that was the reason for the pace increase. He also says on page 33 of the record that it's hard for him to see everyone, which would make it very hard for him to read Mr. Miller's actions, as well as he says on page 33 and 34 of the record that many people were rushing that morning. Also, when Officer Baker requested Mr. Miller to stop, he complied immediately. But even if this court were to find that there was furtive action.
Before Officer Baker did that, before he went to tell him to stop, he also surmised that the defendant might have a gun on him, which was based on his experience with years as a police officer, right?
Officer Baker on page 24 and 25 of the record explains how he views a suspect that's traditionally carrying a gun. Unnatural movement in the gait, adjusting the waistband,
Hands in the pockets.
swinging. I don't believe he says hands in the pockets. He does say swinging of the clothing, as well as subconsciously turning away from police. Interestingly, Officer Baker does not describe any of these qualities in Mr. Miller.
My question is, if those facts were established, would that provide the link in Cibron that you say is, wouldn't that provide the link in Cibron that you say is missing in this case?
The fact
The robbery and the suspect that he's surveilling, in his judgment, seems to be secreting a gun.
If Officer Baker believed that Mr. Miller was carrying a weapon, this would likely give him reasonable suspicion, which would allow for a stop and frisk under Terry. That is not what Officer Baker did. Instead, he conducted a full custodial arrest, which requires probable cause. Probable cause requires a fair probability that the crime is, has, or was committed, using objective facts that are particularized to the suspect. Nothing here is particularized to Mr. Miller.
Let me try the question one more time. 'cause I
Absolutely,
know
Your Honor.
Why you raised Terry, and I understand that that would not allow for an arrest. But in a situation, we know Officer Baker is aware that a robbery has occurred. We know that he's surveilling the area looking for a suspect, and now he identifies someone who he thinks is secreting a gun. And that, what I'm asking is, would you say in the abstract that when you're looking for the perpetrator of an armed robbery, seeing someone in the vicinity of where the armed robbery is, acting in a suspicious manner, and you think they have a gun on them, wouldn't that provide the specific connection to the crime that you say is missing in this case?
If Officer Baker possibly saw that and there were objective facts, which is not the case here, there could be a possible link, but nothing about that still particularizes Mr. Miller to the crime itself. It could just be another person who's armed. Further, U.S. v. Jones out of the 8th Circuit found that there was no reasonable suspicion. And in that case, the suspect was clutching the outside of his hoodie, wearing a hoodie in warm weather, and he was in a high crime area. He was also suspiciously watching the police vehicle. The court rejected that stop and said that there was no reasonable suspicion.
What was the timing in that case between the crime and the observation?
In that case, there had been no crime committed, but it explains how an officer views a suspect who might be carrying a gun, what might allow them to infer that gun.
If I look at Illinois v. Gates, right, and we're looking at a totality of circumstances. So what we're looking at here is the level of suspicion immediately after the crime, 2 minutes, with these other factors. So it isn't he's walking down the street and he's doing certain things and does he have a gun or not? It's do you have the requisite level of suspicion to arrest in these circumstances? So why, and I guess I'm echoing my colleagues here, why if we look at all of these factors, doesn't that pass the totality test?
Because, Your Honor, under the totality of the circumstances, we still have innocent behavior. We don't have enough that links Mr. Miller to the crime. We have a gun inference, but Officer Baker says on page 27 of the record that it's a gut feeling. The state claims possible furtive action, yet Officer Baker contradicts his own testimony. That leaves us with the fact that Mr. Miller was wearing a hoodie in warm weather, walking at a brisk pace.
I'm curious why you raise innocent behavior. Is there a requirement to get to probable cause that the person must be displaying only guilty behavior?
It's not, Your Honor, but you have to have
I don't
objective.
know what that is, by the way. But
You have to have objective facts that are particularized to the suspect, linking them to the crime. Innocent behavior inherently does not link someone to a crime. And when as Your Honor brought up, under the totality of the circumstances, innocent factors can create probable cause. But here, that is not the case.
You seem to want to make the officer judge and jury, though. I mean, you have to admit that these were fast-moving actions going on that morning, and the officers have to quickly gather information that's available to them. And my colleagues on the bench and I have already raised a number of those things: close proximity to the time of the actual robbery, moving away from the scene, covering one's face with a hoodie, walking briskly, hands in pocket. I mean, you have to, I think, give the officer a bit of a break, don't you, under these circumstances? Because he or she has to make, in this case, he has to make a split-second decision.
Your Honor, urgency does not dilute the law. If Officer Baker had a good faith belief that Mr. Miller was the robber, he should have investigated further. A good example of this is U.S. v. Arvuzu. In this case, there was a wire that was tripped near the border, and the officers believed that commonly people travel along this path to avoid checkpoints. The officer comes across the minivan. He sees that the driver is stiff, not making eye contact. The kids have their knees up up as if they're on top of boxes.
But this again is general suspicion, right? It's not a particular crime that's been committed.
In U.S. v. Arvuzu, or in our case, Your Honor?
In that case, Arbuzo.
They believe that they were trying to carry drugs.
Right.
And-
generalized suspicion is a high crime area, same as your gun example. Somebody walking down the street, maybe they have a gun, it's a high crime area, the way they're walking, the way they have their hands in the pocket, or whatever it is, adjusting weight. Here, and I think Judge D'Agostino is getting, it's a response to an armed robbery. And 2 minutes later, you have an officer observe someone walking this way down the street who may be armed and who is coming from the direction of the robbery.
That's correct, Your Honor, but there's still no objective facts. Officer Baker is relying,
I'm trying to understand what an objective fact is as opposed to a fact.
for example, Your Honor, in US v. Jones, the court concluded that him carrying the gun, that the fact that the officer believed he was carrying a gun from clutching the outside of his hoodie, that an objective fact there would have been an outline, a shape, something of that sort.
So is 2 minutes after the robbery would be an objective fact?
It would be, Your Honor, but multiple people were in that vicinity.
Face with a hood, that's not an objective fact?
It is an objective fact, Your Honor.
Walking in a defensive manner compared to everybody else walking on the street, would that be an objective fact?
The fact that Mr. Miller was walking quickly speaks more to the fact that he could have been late for something.
I was kind of referring to the fact that I think Officer Baker says that he's sort of, I don't know what word he used, but he's hunched over.
The Officer Baker says that, yes, Your Honor, he says that he's bumping into people and that he's displaying some hostile behavior. But Officer Baker also admits that this is normal. He says that he's arrested many people in the morning for being hostile.
Granted, and a lot of people wear their hoods, and that's normal too. And a lot of people do walk fast, and sometimes people even walk faster when they see police. But we're doing a totality of the circumstances, so you got to put a plus mark after each one of those observations. And the question at the end of I don't want to torture this mathematical analogy, but the question at the end is, does it all equal probable cause?
It doesn't, Your Honor. Again, when you take the totality of the circumstances, you still don't have enough to say that with a fair probability, using objective facts, that Mr. Miller was the robber of Ruby Jewels. There's not enough there. And allowing this case would mean that allowing the appellate division's decision to stand would mean that any person walking quickly in the morning, wearing a hoodie, being within 2 minutes of a crime, and being within 2 blocks could be stopped and arrested. That would violate the Fourth Amendment rights that protect citizens' rights.
You think a Terry stop would have been better?
Your Honor, I don't believe that Officer Baker even had enough for a Terry stop here.
It wouldn't have been very helpful, would it? Because the weapon wasn't on his person, correct?
Correct, Your Honor, which speaks more to why Officer Baker should not rely on his subjective feelings. He needed to have objective facts to violate Mr. Miller's.
A bit of trouble with that argument, but what if after what you claim is an unlawful arrest, the gun had been in the hoodie pocket? Would that make us give more credit to his feelings?
Your Honor, I see my time is up. May I briefly answer your question? It would not, Your Honor, because again, Officer Baker did not see a shape and outline, any objective facts, none of the factors that he listed during his testimony of how he traditionally sees someone or suspect carrying a firearm.
Thank you, Counsel.
And for those reasons, we respectfully request this court to reverse the appellate court's decision and reinstate the trial court suppression order. Thank you.
Counsel?
Good evening, Your Honors, and may it please the court. My name is Ethan Beach on behalf of the appellant. Tonight I'll be addressing the second certified question before this court of inevitable discovery. Your Honors, inevitable discovery serves as a narrow exception to the exclusionary rule, but it was not ever intended to launder unlawfully obtained evidence through subsequent investigations itself infected by the very misconduct it seeks to cure. Now, that is what happened here. And at the outset, I'd like to address the active pursuit doctrine that's represented in Cherry in the Fifth Circuit, United States in Eng in the Second, and Connor in the Eighth. The active pursuit doctrine holds that not only must the people satisfy the underlying framework of NICS, the independence elements, the inevitability elements, but also must show that the lawful means of discovering this evidence predate the unlawful. Now, that is the right framework to apply here, especially where we have these investigations that are so intermingled.
What's the right policy justification? Because the active pursuit doctrine, I guess we'll call it, is not universally accepted among all the district courts of appeal, right?
Correct, Your Honor.
And do you see anything in Nix that compels a conclusion that there needs to be an active pursuit doctrine? And if so, could you tell me where it is? Because I didn't see it.
Yes, Your Honor. In fact, Cherry is not so much distinct from Nix. If you took the facts of Nix and you transplanted it to a Cherry court, the results would be the same. In Nix, you had a 200-person search party moving in a grid-like fashion directly toward the evidence that was to be suppressed. Now, this search party was established well before and completely independent of any unlawful interrogation by officers of the defendant in that case.
Agreed. Was that a factor that the Supreme Court considered critical to its decision, that it was put together before he made his admission?
Absolutely, Your Honor. It speaks very much to the independence of the alternative line.
Let's say in Nix, change the facts. They get the statement. No one knows. They're in an area, no service. They're driving across the country, across the state. And then after, time-wise, they organize the search party without any knowledge of what happened in that car. Same facts, same grid. And would that be okay?
In the abstract, in that hypothetical in Nix, it would not make as much sense to apply active pursuit as it
What
would.
your rule be that would allow that to happen and not? How would we allow that? Those, my new Nix facts, how could you allow that if it's a bright line rule? Because time-wise, statement, unlawful, interrogation, then search.
Yes, Your Honor. Under those facts, it serves less of a purpose to apply the active pursuit doctrine. If it were indeed in a vacuum, separated from the unlawful conduct.
That goes to independence, right?
Correct, Your Honor.
So why couldn't we just look at independence and inevitability rather than time factor?
You certainly may, Your Honor, and I don't rely solely on the active pursuit doctrine. In fact, under Nix's foundational framework, the inevitable discovery argument still fails.
Why is that?
You'll see, Your Honor, that Officer Owen's investigation was not, in fact, independent of Officer Baker's unlawful conduct.
That's because he heard something that Officer Baker said in his radio call?
Officer Owens, before entering Ruby's Jewelers, heard a radio transmission from Officer Baker that said he had just arrested a man in a camo hoodie in front of 98 Jackson Ave. Now, there are two pieces of information that Officer Owens carries with him throughout the remainder of the investigation and largely relies on from that radio.
If he had never heard that, didn't Officer Owens get enough information from Mr. Martinez to know that the defendant had robbed the store, even if he had never heard that transmission?
Considering that hypothetical, there are still a few issues with Mr. Martinez's. It's not a positive identification. I won't call it that because this is a man who has a hunch that it is this Donovan Miller based on his build, based on his body. And Mr. Martinez views the assailant.
The defendant was Mr. Martinez's employee, was he not?
Allegedly, Your Honor, yes.
Oh, it's not conceded that he worked at the.
I will, for argument's sake.
All right, so let's assume hypothetically. So now we know that they work together. I think we know from Detective Owens' investigation that it was Mr. Martinez who hired the defendant to work at his store. They have some familiarity with each other. And by the way, I'm going to the identification here.
Yes, sir.
Even if at the time of the robbery, Mr. Martinez did not have an opportunity to see the face of the robber, do you dispute that someone who's worked with someone for some length of time, weeks at least, months, I think it was, has a sort of recognition of who they are based on their physical presence?
I would agree with the assertion in the abstract, but not under these facts, Your Honor. You'll see that the assailant was wearing an oversized winter coat and baggy pants when he interacted with Mr. Martinez. Now, it seems pretty far-fetched to assume he could identify him based on his build with such baggy and large clothing on it, which is why it calls into question.
And by the way, I'm gonna do a leading question on you. What did they find when he took that baggy clothing off on the video?
Your Honor, the videotape showed a faceless man. They weren't able to identify the face.
Man wearing.
He was wearing a camouflage hoodie, Your Honor, which served as the catalyst for Officer Owens to connect it to the unlawful transmission of Officer Baker, who had arrested this man in a camo hoodie. It is the only bridge between Officer Owens' search warrant for 98 Jackson Ave and my client, Your Honor.
What did Officer Baker tell Officer Martinez that he saw that happened after the unlawful arrest? Like, as I understand it, what the information that's communicated between the officers is all relative to what happened before the arrest.
Your Honor, going through a causation analysis, the information never reaches Owens but for Officer Baker's radio transmission, but for his arrest.
There's no unlawful arrest. And Baker, there's no arrest yet. Baker calls this other officer and says, I see a guy, he's walking down the street, he has his hands in his pockets or whatever the other signs are. And, he's walking briskly. When he saw me, he picked up the pace, and now he's going into a home and he has a key out and it looks like that's his house. Could he do that?
Your Honor, you'll see that the Nix decision in a footnote 5, discusses the unique quality of inevitable discovery. They say it has no speculative elements, as instead demonstrated by historical facts, the record, capable of ready verification.
But I
Now,
guess what I'm asking is different, I think, and I'm probably not asking it right. But it seems to me that all of the information that's communicated between the officers are observations the first officer made before any unlawful activity took place.
I see what you mean, Your Honor. All I mean to say is that we would be speculating to the record to assume any other world other than Baker transmitting those facts to Owens after his arrest. He was making a
Let me ask it a different way. In this record, is there anything that's transmitted that is the result of the unlawful arrest? Does he say, I have a backpack that, does he say, that has jewelry in it and a gun? Does he say anything that he only learned because of the unlawful arrest?
Your Honor, I would say that the connotation that this man has been arrested, which is communicated in the transmission, would put a negative inference in Officer Owens' mind for the entirety of his investigation. Look, connecting this.
Use that for a search warrant?
Could he use what for a search warrant?
In fact, he's been arrested.
Your Honor, no, that would destroy. I mean, the trial court recognized this and qualified Owens' reliance on Baker as a destruction of the subsequent search's lawful integrity. It could no longer be held out as that alternative line, is what I mean to say.
I'm still not sure there was really any taint in what Officer Owens heard. But if there was, would you concede that it was a tiny, teeny taint?
Maybe using different words, I would not. Still, Your Honor, even if this court is unpersuaded that they agree with the appellate division that this radio communication was negligible, the inevitability argument still fails under that second prong.
Why is that?
Why is it?
Yes, Your Honor. The appellate division relies on United States v. Tejada for this one. They come forward with this language of sure to issue, that the likelihood of a warrant being issued is a real relevant factor in the inquiry. Now, looking at what Judge Posner was comfortable classifying as sure to issue in U.S. v. Tejada makes it more clear why it's not the case here. In Tejada, we had a DEA agent posing as a buyer of cocaine. When he met with the defendant, who had a small blue travel bag with what else but cocaine in it, he was shown the product, was told he didn't want to do the deal there, so let's go to my apartment. He sees the defendant with the blue bag go up to his apartment, hold in the window this blue bag, and after which he's immediately arrested and his apartment is searched in a protective sweep, Your Honor. Now, the officer in that case sees the blue bag in his living room and opens it. Now, the defendant asserted that that was beyond the scope of the protective sweep, so the people relied on inevitable discovery. There, and under only those circumstances, Judge Posner was comfortable saying, listen, this DEA agent, if he made an affidavit, he writes the affidavit, he applies for the search warrant, it is so nearly certain, I believe the words he uses, beyond a shadow of a doubt, that we're comfortable applying inevitable discovery. Now,
I thank you for that explanation. And obviously, the facts of this case are nothing like the facts of that case.
thank you, Your Honor.
The holding isn't that only under these facts does inevitable discovery exist. It's supposed to be illustrative of the principle. And here, where you have an eyewitness to the crime saying, I think this is the person, and then you have a video run by a detective somewhere in the precinct that's showing the individual. And by the way, the person, I think that Mr. Martinez did give Officer Owens the address. Did he not?
That's not correct, Your Honor.
What identifying information did he give? The name?
The only thing that Officer Owens had with him was this employee file that had an image of Donovan Miller from the shoulders up.
His name, I assume.
And his name, that's correct, Your Honor.
So, I mean, my point is, when you aggregate all those facts and you present them to a court, that seems to be what the inevitable discovery doctrine is asking the courts to analyze. Look at these facts and tell us, in your judicial expertise, whether or not a warrant would surely have issued based on what was collected at the time. So just because it's not a blue bag in a living room,
Certainly.
doesn't mean it's not inevitable discovery, does it?
Well, when we look at the circumstances that would be presented to a magistrate, in this case, we have no positive ID. We don't know that.
We disagree with you on that.
Sure.
Do you still have an argument?
There's still nothing in the record that shows Donovan Miller lives or has a unit at 98 Jackson Ave. The search warrant was drafted for 98 Jackson Ave. There are certain deficiencies with that because under Maryland v. Garrison and the Fourth Amendment's particularity requirements, you've got to have something like an apartment number or a unit. You can't just search the entire apartment building, Your Honor. Further, this is perhaps the most egregious error that the appellate division made in their decision, is they ended the analysis with that warrant. They said, if it's drafted, we've got inevitable discovery, essentially. They didn't actually follow the line to discovery. And there's real issue with discovery here because, as we can see in the record, the suspect is seen burning evidence connecting himself to the crime. That he would simply walk home and wait by the evidence until the police drafted some kind of warrant to find it is most unrealistic, Your Honor. Everything goes to show in this record that this is a person who's calculated, he planned ahead to distance himself from being associated with his crime. Now, that could be disposing of the gun, it could be offloading the jewelry, it could be burning the camo hoodie. Why not? He's already done it before. Now, all of these things have to go right for the people for you to find inevitable discovery. I mean, the evidence is suppressed under active pursuit because the lawful means didn't predate the unlawful. It's suppressed under Nix because Officer Owens' investigation was neither independent nor inevitable. There's severe deficiencies with a warrant argument here under Tejada, and there's severe issue with the evidence actually being found. I'd ask this court to not expand the inevitable discovery exception and prevent it from swallowing the exclusionary rule as a whole. And I'd ask this court to reverse the appellate division's decision and uphold the trial court's order to suppress. Thank you, Your Honors.
May it please the court. My name is Connor Skehan, and along with Silas Smith, we represent the respondent, the people of the state of New Scotland. I'll handle probable cause, and Mr. Smith will handle inevitable discovery. Your Honor, under the totality of the circumstances here, it was reasonable for an officer with 25 years of training and experience to believe that there was a fair probability or substantial chance that the man he was observing was the man who had just committed.
So it is a totality of circumstances
Sure.
test, of course. What do you think is the best fact you have? Objective fact.
The best objective fact is the timing and the geographic proximity. So just to correct Your Honor, as you were saying 2 minutes after the crime, it was actually 2 minutes after the 7:30 a.m. dispatch. The record isn't clear at exactly what time the armed robbery occurred, but what it does is that puts an officer receiving the 7:30 a.m. dispatch that a male, had just committed the armed robbery. He's driving west towards Ruby's Jewelers, and he sees a man walking quicker than anybody else, a unique speed, bumping into people without any regard for them.
The time and the place definitely, it puts Officer Baker in the right place at more or less the right time. But I just have to ask, what was it that defendant was doing that was so different than what tons of other pedestrians do when they walk down the street? He's walking fast. Some of us do that. He's wearing a hoodie. Almost everybody owns a hoodie. I'm looking in the room for a hoodie. There's just nothing so special about that. I don't understand how you get to probable cause.
A few things on that, Your Honor. First, you said that, yes, people could be walking as quickly, but as Officer Baker testified, on that day, at that time, he was the only person moving that quickly. That's the record at 25.
So he was the fastest walker on this.
Correct. He was the fastest walker. And then it's the behavior. It's the head down, shoulders hunched with the hood up. And the officer is allowed to make a...
Sorry, but I have to dovetail on this because this very morning at 7 a.m., I left a gym with a hoodie on, with my hands in my pockets, running to get to where I needed to be by 8 a.m. If there's a Dunkin' Donuts across from my gym and it's burglarized as I'm leaving, because I'm running out of my gym with a hoodie on, with my hands in my pockets so I don't lose my car key, that allows an officer to make a presumption about me that I'm the one who robbed the Dunkin' Donuts. That's enough.
If you're the only one on that street acting that way, yes, that gives a fit.
Everybody's running out of the gym to get to work with a hoodie on.
That may be true, but on that day, he was the only person in that area at that time.
The only person on the street.
He wasn't correct. He wasn't the only person on the street, but he was the only person moving that quickly. And if I could just, it's not only that, it's also that when he sees Officer Baker's vehicle, there's an increasing speed. So it's the unique speed at the beginning. It's the sight of the police car.
A lot of people pick up their pace when they see a cop. It's just the way the world works.
I agree, Your Honor. However, what the Supreme Court said in DC v. Wesby is that you don't take a single factor, ascribe it an innocent explanation, like this is just how people react to police, and then completely disregard it. You have to give the due weight based on the officer's training and experience.
I'm not disregarding it because it happens to be the way the world works, but you're trying to get to probable cause, and you're stringing together a series of observations that are very common in morning rush hour sidewalk scenes. Lots of people walking quickly, some of them jostling, some of them got their hands in their pocket because they just came out of the gym. But none of it, I'm very concerned, counsel, that all adds up to probable.
Another way to put that is, don't you really need the observations and the gut feeling on weapon? I think he has a weapon. Don't you really need that to distinguish it from any of this other behavior that could be a gym? And how much weight should we give to that type of assessment by an officer seeing someone on the street turning a different way or adjusting their weight based on his experience?
Well, Your Honor, as Officer Baker testified, he was allowed to make a reasonable inference that, again, the difficult thing about the totality is that we start talking about these, factors one by one, which is, an incorrect analysis in the beginning. You have to take them all together and in light of one another. And so, yes, Judge Cannataro, I agree. each of these single individual factors doesn't reach probable cause. But if you're looking at each factor in light of one each other, it raises the suspicion of each of them. And to the weapon, Officer Baker sees this person with his hands plunged in his pocket, and understandably, there is an armed robbery. And I think the report of the specific crime matters for the totality there and raises that inference to a reasonable inference. Your Honor, in terms of,
But let's say hypothetically, and I know this is a bit unfair because it's a totality test, but let's say you didn't have that assessment that there is a weapon. Could you still arrest this defendant?
so there's no inference at all, no hands plunging in the pocket.
Or he just never draws the inference, same
Yeah.
facts, but he never says, based on my training and experience, that could indicate someone is armed.
Additionally, I believe Baker said at some point that he was concerned about public safety. So the gun his thought that there was a gun was a big motivating factor in his decision to arrest.
If Officer Baker has no inference of a weapon of any kind, I don't believe we have probable cause here. Because as my colleagues pointed out, there's got to be something specific tying the person to the crime. And I think that's one of the factors that gets us there. Obviously, as your honors have talked about, the timing and the location matters. But I agree, if it's a report of an armed robbery and the officer doesn't have any inference that person is armed, I don't think he has a fair probability in that instance. But as your honors know, that's not this case.
Let's talk about it a little bit. Let's explore that gun thing a little. Do you agree with the proposition that at most, based on his hunch, gut feeling, I think that's what he called it, that he could have made a Terry stop, but maybe not an arrest?
Correct, Your Honor. And even you're asking, could he have done a Terry stop, Your Honor? Yeah. Yes, and even the trial court.
But he didn't. So I'm questioning where that gets you on your search for probable cause.
The fact that he didn't do a Terry stop.
You're
You're
arrested.
correct. And
He didn't even find a gun on him, right? On his person.
not on his person, the gun was in the backpack, which was the search after the arrest. However, as the court in Bernagar says, you're allowed reasonable mistakes. As Judge D'Agostino said, we have to give the officers a little bit of a break. I don't think that the exact location of the weapon on the person's body or in their immediate area.
So sure we have to give that much of a break because the officer did assume that the weapon was on the defendant's person, and it wasn't. He made a faulty assumption. That weapon was secreted in the backpack. And doesn't that go to an issue regarding the judgment of the police officer that day?
I don't think that the exact location of the weapon should destroy all the other reasonable inferences from the observations that Officer Baker made.
Should it cast some doubt on our faith in his gut? You got it wrong.
No, Your Honor, it should. I worry there that you're almost going back to almost like an Aguilar-Spinelli test where you're looking at the veracity of the officer knowledge before you're actually deciding whether you can consider all these circumstances. It certainly plays into the totality. It's a factor you can take into consideration, but I do not think it should overwhelm all the other factors.
Why not just do a Terry stop, as we've heard from the appellant?
Well, as Your Honor pointed out, a Terry stop may have not been helpful, but as I read Terry, Terry's not a requirement for finding a probable cause, and I don't necessarily think it'd be best public policy here to say that no matter what, just do a Terry stop all the time. As Your Honor pointed out, these are fast-changing, ever-changing situations, and officers need to make a split-second decision And Terry says, this is a tool in your toolbox. It's not a box to check off on a probable cause checklist. And I think we need to give some fair leeway to the officer's training experience here. And if we're asking him as he's going down the street to, freeze and hypothesize whether he has reasonable suspicion or probable cause, I mean, don't get me wrong, we want our officers to think about it, but we also want, when he knows that there's a report of an armed robbery, there's public safety risks here, we want him to make a swift, he or she, to make a swift decision and arrest the person that he thinks is endangering the community. Your Honor, stepping back and talking about the Fourth Amendment in general, the touchstone of the Fourth Amendment is reasonableness. And Your Honors have sort of brought up some policy concerns about, won't we just be letting the police have free rein to arrest everybody that comes out of the gym with their car keys running to Duncan? And I just don't see that here. I think that what the Fourth Amendment is really concerned about is about arbitrary and oppressive policing. And I think a decision here holding probable cause really encourages the exact type of policing we want in the city of Hackett in the state of New Scotland. We want police officers to be so ingrained in their community, so knowledgeable of their beat or on the streets, so that when they're in these exact situations and they have an armed robbery, they can make swift, effective police work and arrest the person who had just committed the armed robbery.
We still need some type of objective basis for that. I mean, it seems like what you're arguing for is a more subjective standard based on their feelings about what should or shouldn't be going on in the community. And haven't we had a lot of trouble with that?
No, Your Honor. Well, it's true that Officer Baker has, arrested thousands of people, and I think he says in his suppression hearing that there's a problem with guns. The totality of the circumstances of probable cause is an objective standard. So you have to look at it from an objectively reasonable officer. Could an objectively reasonable officer make all of these same inferences, from these objective facts? Objective facts being the report of an armed robbery, the gender of the person that committed it.
On the level, I think Judge Garcia's question is an important one. On what about that equals probable cause or the correct level of suspicion? Your criteria for this person who knows their community and what's normal in their community is almost bound to be more suspicious of the outsider, of the different, than of whoever they think is a normal member of the community.
I think, Your Honor, if I'm understanding Your Honor, your suggestion, it's almost like because of their subjective feelings, they're more.
Really talking about bias.
And that's why this court's review for probable cause from an objective standard to take out that bias.
But I think the way the courts have elected to deal with that problem is show us objective criteria that add up to probable cause, not just a gut feeling.
Yes, I understand the gut feeling was mentioned in the suppression hearing, but here are the objective facts. 7:30 a.m. dispatch, armed robbery had just occurred on Brewer Street. All units respond to the area. We have a description of a male. We have 2 minutes after the dispatch. We have 2 blocks from the crime scene. We have the defendant traveling east, away from the crime scene. We have a unique speed. That's the fact that someone's going faster than everybody else on the street is not subjective. That's an objective fact. We have the disregard for others, bumping into others. We have Officer Baker testifying no one else was behaving that way. We have an attempted concealment of identity with a hood up. We have the deliberate evasive actions upon seeing the police car. And by the way, both the appellate court and the trial court agreed in their factual findings that there's no question that Donovan Miller quickened his pace at the sight of police. That's on the record at page 4 and page 9. So I think I just listed 10 or 11 objective facts there. And under the totality, we would say that that's a fair probability that this was the man who had just committed the armed robbery. I'd ask that you affirm the appellate division. Thank you.
Thank you.
Thank you, Your Honors. May it please the court, Silas Smith on behalf of the respondent, the people of the state of New Scotland. Your Honors, there's a lot to get into because in the 40 years since Nix v. Williams, the federal circuits have disagreed in a number of areas, most significantly, as was discussed by the court, the active pursuit doctrine. But one thing that the appellants mentioned that needs to be addressed very quickly, because if it were true, all I would need to do is sit down because we would have already lost this case, is if a warrant requires an address specific to the unit number within an apartment building, and if that was kind of a automatic defeater of the warrant in this case, that would be very bad for our case. But reading Maryland v. Garrison, the case that the appellant cited, Garrison cites United States v. Bedford as an example of a satisfaction of the particularity requirement of the Fourth Amendment. And it says, a warrant has been considered valid if it specifies the name of the occupant of the apartment against which it is directed, despite the absence of any physical description of that particular apartment. And I have more case law on that if the court would want to consider it. But it's also premature because they could have discovered the unit number as Detective Williams was in the process of developing the warrant. But even if they had never found a unit number, it is not the case that that defeats our warrant. Moving into the inevitable discovery exception proper, as was already been discussed, it requires a court to first view the affairs as they existed at the instant before the unlawful search, and to then ask the question, what would have happened if the unlawful search had never happened? A very important footnote that the appellants rightly raised is this footnote where the Supreme Court says this: no speculative elements, but rather a focus on demonstrated historical facts capable of verification and impeachment. I'm sorry, Your Honor, I didn't want to cut you off. You were going to ask a question. I apologize.
I mean, I was thinking of a question, but since you stopped, I'll ask it.
Yeah.
As malformed as it's going to be. Would you say that at the time Officer Owens stopped the warrant process, that he had collected enough information to make the issuance of a warrant inevitable?
So, Your Honor, at about that time, which I believe in the record was around 8:05, what Officer Owens had been able to assemble, and the short answer is yes, Your Honor. I apologize. The short answer is yes.
What is it that Officer Owens had that created that inevitability?
So there was although the appellants are correct to point out it's not the strongest identification, Mr. Martinez did have a personal identification of the suspect, but and of course that's the starting line, not the finish line of where the police were able to end up. The most important information, the officer.
Something about that.
Yes, Your Honor.
Is an investigating officer entitled to rely when the victim of the crime says, "I really think it was this person who did it," and maybe they didn't see the face, but they have a reason to believe that. Is the officer entitled to rely on that in terms of forming a suspicion?
Well, number one, Your Honor, as you mentioned during the previous argument, it's coming from a place of familiarity between people. Oh, and that's very important too. Both of the lower courts found that Mr. Miller was the former employee of Ruby Jewelers, so that's true. There was a little confusion there about whether he had ever been employed there. But it's coming from a place of familiarity. But second, Your Honor, to your point, absolutely not. If Officer Owens had just walked out of the store and just gone to a magistrate and said, "Hey, I have this type of personal identification. Let's go find this guy," that wouldn't be enough because it's a little too generalized. But it's still relevant, and it would still have been in the application as I said, the starting line, not the finish line.
Martinez says he did it. You go to the magistrate and you say, "I want a warrant because Martinez told me that he did it."
I don't think there's any neutral magistrate who would issue a warrant. Well, the most important thing, Your Honor, there's two things. I'll start with Officer Owens, but then it's also important to return to Officer Baker because he actually has a significance in our argument. Officer Owens, the most important thing he discovers with the help of Detective Williams is a surveillance camera footage that shows, although the appellants correctly know it doesn't show the face, but it does show three things: camouflage hoodie, cargo shorts, and a backpack. That description of the suspect fleeing is something that Officer Owens was able to discover, and we would argue would be absolutely have gotten to that point even if he had never heard the 7:35 a.m. radio message, because that's just the product of his conversations.
With respect to the camouflage, I think you're treading on dangerous ground here, because I feel like your adversary's argument is that was planted in Owens' mind by the radio. look for a camouflage hoodie. So when he sees that on the tape, that's potentially a problem.
Your Honor, yes, that to give what the appellants are saying is that is something that our argument needs to address is hearing the words camouflage hoodie before he enters the store, what effect would that have? But Your Honor, even if there would be a difference in the significance he would have attributed to the camouflage hoodie, the only thing I was trying to bring to the court's attention is he would have a very good description of what the suspect was looking like at the time they fled the scene.
Except for his face.
Except for the face, Your Honor, unfortunately.
Straight judge might quite interested in.
Again, Your Honor, we're trying to, yeah, it's just baby steps, Your Honor. We're trying to get to the finish line here, sorry. But what one language that the court used that I thought was very important was, and this goes to something Judge Garcia mentioned and something that Judge Agostino mentioned, the radio message. So returning to Officer Baker, his plain view observations of the suspect's camo hoodie and the address remain in the record as demonstrated historical facts capable of verification or impeachment, even if his arrest never occurs.
And that goes to me to independence prong. Where I have more trouble with your argument is inevitability. So walk me through why, first of all, what they're going for that I think the argument is becomes an inevitable process that will lead to this discovery is a search warrant.
Yes, Your Honor, for the apartment specifically.
And so in Nix, we have a case, and forget active pursuit, but in Nix, we have a case where you have sweepers, let's say, going across a field grid. They're moving from left to right here. The body's on the other end of this field. And you can say, given the grid and given the motion of those sweepers, they're going to discover that body. What's the analogy to I'm getting a search warrant where I think a bag that isn't there when it's recovered is going to be?
So, Your Honor, two things to just address Nix and then move back to our facts. In Nix, Your Honor, you're absolutely correct. In Nix, and also when we discussed Tejada, these are very strong, almost kind of best case scenarios for the showing of inevitability. But Your Honors, even in Nix v. Williams, the reason why the court adopted a preponderance of the evidence standard is because even with that very organized search party and even with that very detailed grid search, the searchers would have still had to go many miles over many hours and search an unknown number of hiding places. So that's why, Your Honor.
Contingencies are limited, right? Because the evidence in that case isn't moved.
Well, to your point, Your Honor, the contingencies are different. And even the appellate division acknowledged that Nix has some ambiguities. And one of the ambiguities it has is what to do with the contingency when a warrant is involved in an inevitable discovery argument. And that is actually where we could begin to discuss the active pursuit doctrine, because that's an attempt by the Fifth Circuit to address that. But
even before we get to active pursuit, even assuming it doesn't apply, I have trouble with the connection that this bag will eventually be in that apartment.
so, Your Honor, this type of evidence at issue in this case, stolen property, clothing, and firearms, as the Third Circuit said in U.S. v. Jones, the inference that magistrates make all the time is that this type of evidence specifically is the type of evidence that suspects would stash in a very secure location, their most secure location, their residence, as opposed to less secure places. And Your Honor, in the showing of would that have happened, would that very rational inference have occurred, you can't get much better than the guy literally going up the steps to his building before he gets arrested.
I believe their argument would be he's only doing that because the police are there.
That's a very important question, Your Honor, because two things I would say to that, Your Honor. As I've read both of the lower trial courts, they both classify the movement on record, on the page of a record 12 specifically, they classify the movement that Officer Baker saw as an acceleration towards an already determined location, not as recognition of the police and then a deliberate attempt to flee. And Your Honors, even if your court, and we would urge the court to remember to give due deference to that finding, but even if your court finds that to be, this court finds it to be clearly erroneous, what would be difficult for my argument that it's calling into question, well, was he really going to the apartment or did he actually flee to the apartment? In that case, I know this is a separate argument, but that would be very significant for Mr. Skehan's argument, because now we're talking about flight. Now we're talking about a change of direction. But the lower court said he was going there.
Does it help her or not make a difference for purposes of this inevitable discovery argument that he raised a ruckus, sort of yelled in the direction of the building, and all these people came out who arguably knew who he was and were trying to defend him? That factor in at all?
To Your Honor's point, I think what Your Honor might be implying is, couldn't they have helped him in another way if he had successfully gotten into the building? Is that kind of what your question's getting at?
No, I mean, in terms of whether or not we're confirming that this is his home, I guess a bunch of people coming out and acting like he's their neighbor might be helpful to you. Wrong way to look at it.
I think, well, it is his home, Your Honor. I'm sorry if I'm misstating if I said he wasn't. Yeah.
This could further confirm
Oh.
that it was his home.
Right. But Your Honor, so if that was something that had happened pre the misconduct, absolutely, that could have been helpful. But the problem is, because that happens after the arrest, that isn't something we would have the benefit of.
Suppressible because
I'm sorry, Your Honor.
saying it would be suppressible.
The evidence, or that fact that the people are coming out of the building. Well, Your Honor, because as the Sixth Circuit said in U.S. v. Kennedy, the first thing we have to go to is the instant before the misconduct, which for the purposes of this alternative argument is the arrest.
Okay.
Yeah, that everything post that. Yeah. And Your Honor, an important thing is, because that footnote I mentioned earlier, this is very important, the no speculative elements. Your Honors, all of the circuits that have incorporated that footnote into their case law really interpret that sentiment to mean that the Supreme Court is talking about speculation of certain kinds and to certain degrees. Because, Your Honor, even as U.S. v. Ang, the case that the appellants quoted from, it's U.S. v. Ang in the Second Circuit, it says, by its nature, inevitable discovery analysis inevitably involves some degree of speculation. So it's not the case that we can't do. Some circuits prefer to use the term reasonable conjecture or necessary conjecture to try to maintain the distinction between speculation versus conjecture, whatever we want to call it. The Supreme Court is kind of getting at speculation to a degree and to a kind. And the strongest thing that we have here for inevitability is that everything we're talking about in the record happens within the first 30 minutes after the robbery is reported, and only 2 blocks away, an officer makes plain view observations of a man who matches the exact photograph that another officer would hold in his hand not even 15 minutes later. And here a description of surveillance footage showing a man wearing a camo hoodie, cargo shorts, and a backpack. Your Honor, in inevitable discovery arguments, courts are allowed to consider routine procedure. Once Officer Owens had that description of what the suspect had done, stripping off his outer layer and walking away on foot, matching that description, we think it's, by a preponderance of the evidence, much more likely than not that he would have either radioed all available units, or, as Officer Baker completed his journey to the crime scene, discussed that with him.
How much
Lots of
weight?
assumptions there. Go ahead, Judge.
How much weight should we give to the nature of the underlying violation? So I think they mentioned Tejada, which, as I recollect, they're in the apartment lawfully. What they do is they search a bag incident to that arrest, which goes beyond the protective sweep, right? So they don't have a warrant for that. But there's no violation of them entering the apartment. And I think the judge in that case put a lot of weight into that it doesn't affect kind of a core interest of the Fourth Amendment, the sanctity of your home. Here, the violation would be an arrest of someone in the middle of the street and handcuffing them. Seems a little bit more severe than I arrest you lawfully, I do a search incident to arrest, and then I unlawfully search your bag.
Your Honor, yes, that the police did have the right to be in the apartment in that scenario, and that is something that distinguishes Tejada from this case. But as Judge Cannataro mentioned, Tejada, it's kind of a best case scenario, and we would just ask this court to apply that scenario to a high showing of a magistrate finding probable cause for a warrant, even though the facts are distinguishable, Your Honor. But in another way, the fact that this doesn't involve an attack on the home, in a way that does kind of help our case, because we're not directly, the misconduct in this case didn't directly attack the Fourth Amendment. As the Supreme Court has held, the exclusionary rule is no longer bound up with the interests of the Fourth Amendment, like, Your Honor, entering a home. It's a judicial remedy that should only be exercised when it's appropriate. And in this case, and my time's just about to expire, but Judge Agostino, you mentioned a lot of assumptions. The Second Circuit kind of uses this framework of like a string of contingencies, and that the police have to meet a more likely than not standard for each of those contingencies. So we would just ask this court to consider each of those factors that we've mentioned. And even though, yes, this isn't a best case scenario like Nick's, like Tejada, we do just respectfully submit to this court that when an officer is holding a photograph of the suspect, has seen footage exactly describing the suspect's outfit as fleeing the scene, and an officer 2 blocks, 2 minutes away has very recently made plain view observations of that exact suspect wearing those exact clothes entering that apartment, by the preponderance of the evidence, more likely than not, they would have been able to get a warrant. My time has expired. We respectfully ask you to affirm the appellate division. Thank you, Your Honors.
Thank you, counsel.
Your Honors, I'd briefly like to address a few things. The state relies on DC v. Wesby to say that the officer's Baker's experience is given weight, yet Officer Baker's experience only helps him interpret facts. It doesn't allow him to create them. And this goes to what the state also said, which was that they admitted that if there was no inference of the gun, that there would not be probable cause. Yet Officer Baker, using his 25 years of experience, describes on page 24 and 25 of the record how he views a suspect carrying a weapon, and that he saw none of these in Mr. Miller. Briefly addressing the inevitable discovery, nothing in the record indicates that 98 Jackson Ave is Mr. Miller's home. And
It's not difficult to get information like that, though, in today's world, is it? You can get an address like.
But nothing in the record, Your Honor, no historical facts in the record point to the officers being able to do that or wanting to do that. And without that, you're speculating, which is exactly what footnote 5 in Nix warns against. And for those reasons, we respectfully request this court to reverse the appellate court's decision and reinstate the trial court suppression order. Thank you.
Thank you, counsel.
Thank you.
All right. Please be seated.
Okay. As the judges deliberate, we will now announce the awards for the 2026 Gabrielli competition. I would like to welcome and introduce our 2025 Gabrielli competition winners, Nathan Madison and Victor Gelfuso, to announce the awards. Welcome down. Gentlemen. Thank you. And as we do that, while your name is announced, please proceed down to the floor, come accept your award from me, and take a quick picture. And we'll try to kind of keep a bit of an efficient pace here to keep pace with the Court of Appeals deliberations. But okay, thank you, gentlemen.
I'll go first? Sure. All right, we will now start with our 2026 Gabrielli Octo finalists, Madeline Sharkey and Rebecca Bogod.
Rosalie Desir and Leah Roth.
Rosalie Desir and Leah Roth. Sophie Nye and Keely Robinson.
Alex Myers and Jacob Kindlin.
Brian Morano and Allison Struther.
Very excited for everybody. Jillian Kavanaugh and Beatrice Pulley.
Andrew Jensen and Daniel Severia.
Grace Gyron and Tyler James.
Next, we will announce our quarterfinalists, Catherine Benedetti and Timothy Nolan.
Alexi Holt and Sean McEnany.
William Lombardo and Nicholas Telgheater.
Alexander Page and Basir Rezik.
Next, we will announce our semifinalists, Joshua Hume and Bryant Kazakana Pilataxi.
Sarah McDonald and Mackenzie McKeel.
We will now announce the winners of the Best Brief Awards. The winners of the award for third Best Brief are Sarah McDonald and Mackenzie McKeel.
The winners of the second best brief are Luke DeFio and Ethan Beach.
And now, the winners of the 2026 Gabrielli Competitions Award for the Best Brief are Bryant Kazakana Pilataxi and Joshua Hume.
Now for the winners of the Best Oral Argument prizes. For third Best Oral Argument goes to Alexander Page.
The winner of the award for second Best Oral Advocate is Silas Smith.
The 2026 winner of the Gabrielli Competitions Award for the Best Oral Advocate goes to Sarah McDonald. Congratulations to all competitors. Amazing rounds of competition.
Okay, congratulations to everybody who received an award. We will now wait for the judges to finish their deliberations. And when we do, we will reconvene. Thank you very much. Okay, it was a quick trip. The judges are ready to provide their feedback, so if you'd all please take your seats. We will welcome the judges back in.
All rise. Please be seated.
Oh, thank you all. Thank you to all the participants. We never say this in our day jobs, but this is the part as judges we hate the most in this competition where we have to announce a winner because you're all so excellent. And obviously to get here is a tremendous accomplishment, and it was obvious why you were here. You are all excellent advocates. You did things not only in terms of the substance of your arguments and knowing the record and knowing the case law, but on style points, on how to handle some difficult questions, some probing questions, and what not to do in response to some of those things. And it was really a pleasure to judge this competition. So I congratulate all of you on a terrific job. Well done. And I'll obviously let my colleagues speak, but before we do that, I will announce the winner, which is the appellants team. Congratulations, and congratulations to you as well for an excellent job. But Judge Cannataro?
Yes, I echo. First of all, thank you for having me here. This is my first Gabrielli, and I really enjoyed it. And this was such a treat to see two such phenomenal teams. I agree with everything Judge Garcia said. This one was incredibly difficult. I think the decision rested on the breadth of a hair because we saw such great performances and such really admirable traits and characteristics from both sides. You handled things in ways that I think, although we didn't say this during our deliberations, people who appear in front of us in our real courts every day don't handle the things that came up as well as you did. So I think you should be really proud of yourselves. I will agonize over whether we made the right decision for at least the rest of the night. So that's always a good sign. And I'm just so privileged to have been a witness to this. Thank you.
Thank you. What a privilege to listen and watch to all four advocates. You had a mastery of the topic, a mastery of the record. All four of you are really wonderful oralists. Such a pleasure to be here. And when I compare what I saw tonight with what I sometimes see during oral argument in my own courtroom, I can tell you that each one of you would be able to step into my courtroom tomorrow and make yourselves proud. At this level, hundredths of millimeters separate the teams because you are the top two teams in the school, and it's very difficult to make a differentiation between the talent that we saw tonight. So both sides should hold your head high. You made it all this way. You performed so admirably tonight in front of a pesky bench, a hot bench, lots of questions. Well done, all of you, and thank you.
So I think there's a reception after this downstairs. And we're happy to talk with you. We'll be around and talk about the argument in more detail. But as of now, I think we are adjourned. Thank you all.